I am very grateful to Montek for agreeing to chair today's session.
Am I chairing?
Yeah. And also to Rakesh for being here today and also sharing with us all. In case you haven't seen it, I'm sure they can send it to you in case you are not part of the number of people to whom the email has gone to invite you for today's discussion. Gurmeet here can always, if you give her your card, send you the email because it has got 3 separate attachments which are relevant for today's talk. Not the one that he is going to share with us, but what Rakesh has written, what I have written, and some numbers. So do look at them at your leisure whenever you can. They'll be useful. What can I say? Rakesh and MS, calls himself MS. That's for M. Sahoo, Madhu Sahoo. We have worked together in the Ministry of Finance at the same time. He, of course, is from the Economic Service and has gone on to the National Stock Exchange and then from there to SEBI, and then was the first chairman of the Insolvency and Bankruptcy Board of India. So I thought, who better than him to talk about defaults and how they're addressed by the NCLT and NCLAT. For those who are not familiar with those acronyms, that's the National Company Law Tribunal and the National Company Law Appellate Tribunal. And in both these bodies, you don't have to be a lawyer or even have a law degree to serve on these judicial bodies. So I don't know how and why that has happened, but all of these mysteries MS will reveal and explain to us. All I can say is he thinks that things have improved. Yes, they've improved from a very low level, but we still have far too much that is written off. Just last year, fiscal year 2023-24, we have ended the fiscal year 24-25, but the numbers are not yet out because it's just ended 2 weeks back or less than 2 weeks back, 8 days back. I noted that the amount of public sector loans that were written off were about 1,12,000 crores.
For those who are not public sector bank or public sector borrowers?
No, public sector banks have had to write that off.
That's an important.
Yeah. So for those who are not familiar with this term crores, that's 10 to the power 7. So it's 10 million. Okay, I'll stop here now and hand over to the chair, that is to Montek, for his opening remarks, and then we'll proceed. Perhaps MS will make his presentation then. Thank you, everybody, for coming.
Well, thanks very much, Jaimini. Thank you for inviting me, first of all, to chair the meeting. I assume that my primary qualification was not having worked in this area to any significant extent, and therefore being more objective. But anyway, thank you and welcome, everybody. And to cut everything short, I'm just going to ask Mr. Sahoo to make the presentation. Then Rakesh will give his comments. And I propose to then have as much discussion as possible. So, go ahead.
Thank you, sir.
Will you allow two-handed interventions to clarify something?
100%, 100%.
If somebody wants to interrupt him,
anytime welcome.
Just stick up both hands.
Yeah, thank you.
Go right ahead.
So thanks to CSEP for giving me this opportunity. And extremely happy because I'll be talking on something which is my favorite subject. But more importantly, this is something which we broadly consider as last major leg of economic reforms, which Mr. Ahluwalia and other people sitting on dais, they were the architects of economic reforms of the 90s. And they did something which created market economy, which created competition, free entry, all those things, and the businesses grew in size. But they inevitably ended up with some problems that in a market economy, essentially, as we unleash the competition and innovation, in competition, efficient firms drive out inefficient firms. in innovation, new order drives out old order. So essentially, because of the competition and innovation, we have failure, and failure is inherent in a market economy. And we needed to handle this failure little smartly rather than penalizing the people. We wanted to that a viable farm should not die. We should rescue a viable farm, close an unviable farm. But this is a market economy. Let market decide what is viable and what is not viable. In the process, liberate the entrepreneurs and the resources. Essentially, this is about the freedom of exit after having freedom to enter into business in the 90s, allowing them to compete, grow, and all those series of reforms that we saw in 90s and the decade beginning in 2000. But fast forward to 2010, when we had a growing market economy, very high growth rates, actually sometimes touching the double-digit growth rates. Loans were also little easily available. People used the leverage, and that created some problem. We had the situation of twin balance sheet problem. I think that term was coined by Mr. Arvind Subramaniam in 2016, when the bank's gross NPA was about 4.3% in March 15, went up to 9% in 16, and in fact, it continued beyond till we saw some major impact of IBC. So by mid 2018 or so, it went up to nearly 14%. About 50% of the companies having interest coverage ratio less than 1 by 2015. So kind of we had a chakravyuh, both viable, unviable firms got stuck up and there is no way to get out. We had some regime earlier, SICA from 1985, those were non-functional practically. At least the SICA, that was a government machinery that has to recognize if somebody is sick and also do the revival. Other were clear recovery in the amendment to Negotiable Instruments Act, making the check issued if it degenerates, it becomes a criminal offense. The DRT, surface I, all those are recovery things. There is no resolution mechanism actually. So then we got this IBC. I just wanted to spend a little time on the objectives of IBC. This actually reads like this, that this is a law for reorganization and insolvency resolution of corporate persons, proprietary firms, and individuals. So that is the objective, that it is for essentially in English, you can say the stress resolution of the businesses or partnership firms as well as also the individuals. And it provides a manner of resolution. That manner is you do it in a time-bound manner. And further details are in the body of the law, like the moratorium, clean slate takeover, interim finance. A lot of modalities have been prescribed how this resolution would happen. And if you do that resolution in this manner, you are likely to maximize the value of assets of those persons, assets of corporates. I wanted to emphasize that sometimes we confuse that whose value we are trying to maximize. And if you do that, these are the sentences, time-bound manner for maximization value, to promote entrepreneurship, improve availability of credit, balance the interest of all stakeholders, and alter in the order of a priority, that is the waterfall, and establish Insolvency and Bankruptcy Board of India. And time and again, we have seen the judicial thing saying that this order of objectives is sacrosanct. But I look at it a little differently, since this is a group of mostly economists. The first Nobel laureate in economics, Jean Burson, he had a public policy guidance that no public policy should have more than one objective. If you try to achieve more than one objective, likely to have problem. So I read that, I am reading the exact long title, that it is its only objective, it has one objective. That objective is stress resolution, insolvency resolution. The rest is how you do it, and if you do in that manner, if you do in the manner the Companies Act provides, the outcomes are likely to be different. But if you do in this manner, you will maximize the value, which in turn will give these benefits. So objective is only one, insolvency resolution. And if you do it in this way, you will have certain benefits. And it provides stress resolution in two ways. I'm mostly focusing on the corporate part, though the law is applicable for corporates, individuals, proprietary partnership firms, but it is practically in operation only in respect of corporates today and the guarantors, personal guarantors, as well as the corporate guarantors. So I'm focusing the discussion in relation to the corporate insolvency resolution. It provides a resolution in two ways. Either you resolve through a resolution plan. It provides the detailed process, how you start. It starts with a default, the process ends up either with a resolution plan or a decision to liquidate the company. The market finds that this is not a feasible, viable company. There is no one who is willing to take it over. In that case, the company should be closed. And this decision is with the committee of creditors. As I told, it's a market problem. Market must solve it. The committee of creditors have been given the authority to decide, and they can decide within 1 month of initiation of the insolvency resolution process that this is not a viable, feasible company. Let's close it. And if they do not take that decision, the time gets over, the company automatically moves to liquidation. So the law expects that there are only two ways of resolution. One is by resolution plan, other is by liquidation. At times we have a confusion, particularly because Supreme Court has told 100 times that every effort should be made to resolve the company. And by resolution, they mean the resolution by a resolution plan. But resolution can happen through liquidation, that most of the people, at least the judiciary, still does not understand, though we have been talking repeatedly that liquidation is also equally permissible, legitimate means of a resolution. And what we are essentially resolving is that if a company is not doing well on account of competition, innovation, forget about the dishonesty part for which there is a separate provision in the law to deal with. But if just because of the market forces and business is not doing well, essentially the resources at its disposal are underutilized. So if it is a viable business, so there must be someone who would be willing to take over this business and revive it. And if it does not have a viable business, there will be no takers and this should be liquidated. In either case, the resources are put to better use within the same premises if it is resolved by a resolution plan, or if the resources are liquidated, given to the people, the stakeholders who had contributed, they can reinvest it. But there is a slight bias in favor of a resolution because the route of liquidation takes a little longer to channel back the resources to productive use. So that's why some facilitation like interim finance, moratorium, and there is no direct way of proceeding to liquidation. Unlike in some economies, they allow you straight away go for liquidation, but we first initiate a resolution process, let a collective body of a committee of creditors come up and then take a business call. So we do not allow direct liquidation. There are some facilitation for revival. This is the ecosystem. We have NCLT, NCLAT, which Dr. Bhagwati was talking about. These tribunals and regulators, this is actually a copy paste of the model we got in the early 90s. Dr. Bhagwati had worked on this in case of securities appellate tribunal, and that was the time when this technical member and judicial member positions were created in 99 Amendment Act. When before that, SAT was a single person bench. It was made a division bench thereafter. And in all tribunals and in division benches, the practice came that there will be a judicial member and there will be a technical member. And in all these non-judicial bodies, company secretary, chartered accountant, cost accountants, advocates, everyone is allowed to provide representational services. So this company law board, NCLT and NCLAT, were actually created for Companies Act. This work was loaded onto them. And there are a lot of other people who assist in the process, insolvency professionals and valuers. These are very extremely important. IBBI is something unique. Actually, we do not have a regulator comparable to IBBI anywhere else in the world. I would just mention on the way how it has moved. Only one aspect I would mention is that the First Amendment Act, the very first resolution plan that happened was in respect of a Synergy Dure Automotives Limited. That happened on 2nd August 2017. That was a case where the company owed 900 crore to the creditors. The resolution plan got 54 crores. So the creditors got 6% of their amount due. The liquidation value of the company was 9 crore. So they got 600% of the liquidation value. 6% of the claims due. And this happened all in time. The very first resolution plan, there is no timeline issue. It got completed in 180 days time. But it got a huge criticism that the criticism was that, is this the insolvency law we wanted, where creditors will take a haircut of 94% and the company, in that case company, remained within the same group. The resolution applicant came from the same group. That means the persons who were responsible for running down the company are retaining the company. Nothing happens to them and creditors are taking the haircut, and this was not acceptable. This brought the very first amendment in November 2016, saying that the famous section 29A came, which told that, because this had a profound implications thereafter, it told that anyone who is suffering from any of the following disabilities, the ones like the insolvent, undischarged, willful defaulter, or has been debarred from accessing the security market, becoming a director of the company, or has some criminal background, penalized for 6 years imprisonment, and such contraventions anywhere in the world, not only in India, and all the relatives, all of them were prohibited. That there has been some dilution thereafter, but that changed the complete credit culture in the country. Several amendments, the last one was in the context of COVID. Courts have been very kind, though there have been some misinterpretations, but generally they upheld the provisions of the code. Two important features I just wanted to mention. One is that when the company is under stress, so there are not enough to meet the claims of everyone, whosoever has to get something. So then there is likely to be a run on the, I can do from here. Okay, thank you, sir.
But I regret to say you have to be much faster.
Yes,
If you really want to get to the end.
30 minutes, na?
Okay.
Okay. So essentially what was done was, those who have this insolvency law says that you forget all your pre-insolvency rights, we rewrite your entitlements, and all of you will be bound by these rewritten rules. This is we call priority rule, and once it is once we override all your pre-insolvency rights, this waterfall or priority rule under IBC law will prevail over every other law. So this is what comes in the waterfall. The second principle is the committee of creditors who have got extraordinary powers, to the extent that though people who do not sit on the committee of creditors, they can write up dues of others. They are the private people. They decide how much they will take and how much others will take. And that has been contested many times. Supreme Court finally upheld that commercial wisdom lies with them, and they will decide who will get how much. And the resolution plans they can get from anywhere in the world. So with this, I will be moving to the transactions. So this is what has been the transactions. You can look at that. 8,175 companies have been admitted so far. Of them, 1,236 have been undone through some review process, appeals or settled. 1,130 withdrawn. Resolution plan has been approved in 1,119 cases. Liquidation has commenced for 2,700 cases, and about 2,000 cases are ongoing. Corporate insolvency resolution process. Yeah. So this is how the process begins with a corporate insolvency resolution process. When there is a default, the debtor or creditor, both of them are entitled to approach the NCLT saying that a default has occurred, kindly admit the case to CIRP. If the NCLT is satisfied that there is a default, we move to an objective measure so that there is not much debate, or the NCLT should not take much time to decide it. So this is how we have about 8,000 cases admitted to this process.
The column appeal/reduce settled and the column approval of resolution plan. So what's the distinction between these two?
Distinction is that I am a creditor. I filed an application with the NCLT. NCLT admitted it. Possibly there was something wrong in NCLT admitting. Somebody went on appeal. NCLT set aside NCLT order. That means the company goes out of the CIRP. Possibly also somebody went and told that, okay, I am settling the matter, so let's close this matter now. And the approval of resolution plan is it runs the full course. Withdrawal happens also in between. And actually I will give some more numbers which happens before this appeal, before the admission. But the real outcome is the approval of resolution plan 1100 has been closed by resolution plan, 2700 have proceeded to liquidation. So this is a little more numbers. Companies which have been rescued by resolution plan 1119, there were claims against them about 11.40 lakhs. Liquidation value of those companies was about 2.2 lakh crore. The liquidation value as a percentage of claim was 19%. So assets available on the ground was 2,20,000 crore. Claims against them 11,40,000 crore. That means when they started insolvency process, they had the assets valued at 19% of the claim. The resolution plans gave them 3,57,000 crore. So the resolution value or realized value as a percentage of a liquidation value is 163%. The 63% extra is, you can say, the going concern value. If the company were liquidated, we would have got at best the liquidation value minus the cost of liquidation, but we are getting 63 just because of the going concern surplus. But in comparison to the fair value, we are getting 88%. The resolution realized value as a percentage of claims is about 32%. The time taken on average, I'm talking about the entire 7-year period. If you see the current time period, things outcomes are slightly different. But if I look at for entire 1119, the average time taken has been 701 days as against the statutory requirement of 180 days, extendable up to 330 days. Under no circumstances to go beyond 330 days. Cost as a percentage of resolution value has been 0.77% of the resolution. The companies which have proceeded to liquidation, 2,700 have gone to liquidation, but of the 2,700, 1,274 have completed the liquidation process. So the figures in red, those indicate the in respect of the closed liquidation. Liquidations are complete, assets have been sold, and whatever was realized have been distributed to the concerned stakeholders. Company has been struck up the register of the by the registrar of companies. Yes, yes. In fact, the data are available in US actually. 75% cases they start with liquidation. Cost of resolution. Oh, sorry. Okay. Yeah, it is comparable. In fact, ours is just, maybe 50% of the global average. But cost has started increasing of late. And we have cost data for about this resolution part. For liquidation, we don't have cost data. Yeah, 1.2, 1.3, something like that. So these 2,700 companies, they owed 13 lakh crore, but liquidation value of those companies was 60,000 crore, meaning that only 5% of the claim was available in the form of assets. from the companies that have been completely liquidated 1274. Against them, the liquidation value was 14,000 crore. Liquidation value, liquidation realization as a percentage of claim, they got 3.6%, realized value 13,140. And this is how 508 days it has taken. So if you look at the numbers, 30% of the companies have been rescued, 70% have been liquidated. But if you look at the value of the stressed assets, 77% of the distressed assets have been rescued, 23% have been liquidated. Of the companies which have been liquidated, 40% were, of the companies which have been rescued, of them 40% were defunct. Companies which have been liquidated, have proceeded for liquidation, of them 78% were defunct. The example of Synergy Dura I gave you, that was a defunct company since 2002. It was in BIFR since 2002, and because IBC came, it was transferred to IBC. This realization, what figures I gave you, that 32%, meaning 68% haircut, these excludes certain other values which are in the process of realization, like 3.85 lakh crores are stuck up in avoidance transactions. Applications have been filed for realization from personal guarantors to the extent of 2.4 lakh crore.
Can you explain what figures in red
After CIP fails, companies proceed to liquidation. 2,700 companies proceeded to liquidation. But liquidation itself is a process. So of this 2,700, 1,300 have got out of the liquidation process. That means assets have been sold, the sale proceeds have been distributed, applications have been made to NCLT and register of companies. Register of companies have struck up them from the register. So the rest are still in the process of liquidation. But in any case, the expectation is that we will get only 3 or 4% of the claims through liquidation process. The last line, that 2,800 or 30,000 applications. 30,000 applications were filed with NCLT. They had an outstanding default of 10 lakh crore, but those were withdrawn before admission. So this is considered that is an impact of the section 29A, that once it is admitted, in all likelihood, company will move away from the existing promoters. That fear is working. People do everything that this is not admitted. And people use this as a threat. Mostly the operational creditors use this as a threat. They have actually, even before this is a stage, they have to give a notice to the corporate debtor. At that time, many people come and settle. And if still they don't settle and they go to NCLT, 30,000 such cases have been settled. So that's a realization. The underlying default for those 30,000 applications is about to 10 lakh, 11 lakh crore. This government claims that this is also realization, but there is a question mark on that. Resolution plans have given total this much 3.57 lakh. Liquidation has given so far. This year you can say the ready cash, almost ready cash, 13,000. Voluntary liquidation 9,000. Gross GNPA, which was at a peak of 14.6 in March 2018, has come down to 2.6 in September 24. Not that entire impact is because of the IBC. There are several other things, but it has a substantial impact. And bank profits as against a loss of 32,000 crore in 17-18 has changed to a profit of 3.5 lakh crore in 23-24.
What do you conclude from that last figure?
This is profit, sir?
Yeah, the last bank profit.
So that means the amount which they used to write off earlier, the write-off has reduced.
Yeah, I mean,
yeah.
Okay.
So this is in terms of performance, in terms of timelines. Figures in red relate to the year 24-25. That's why I told that of late, these have become a little worse. If you look at, let's say admission, first line is admission. Admission now takes about 2 years. People come for admission after 3 to 5 years of a default. Admission takes 2 years. from insolvency commencement date to approval or resolution plan takes 701 days on average, 821 days for the latest year. So that is about 2 years. Liquidation takes about another 3 years. So the entire process, if you look at the line, total line, 3 to 5 years for initiation, 2 years admission, 2 years CRP, 3 years liquidation. So total process, you can say from the date of default is about 10 to 12 years for conclusion now.
So how does that compare internationally? My guess, I mean, I don't know.
Internationally, sir, the past I told 3 to 5 years, this is almost zero internationally. Ours by law, it should happen in 14 days time, but not happening because of 2 reasons. One is the NCLT, and in fact, it has been a little more become worse because of a recent Supreme Court judgment, which says that yes, a default is there, but why there is a default also NCLT look at. We moved away earlier, we had the concept of insolvency, balance sheet consideration. We moved to objective figure, default is there or not. But if you waste time in finding out whether this default is something temporary, has an underlying reason, then you waste
Isn't
time.
that a fatal flaw? I mean, it's a
Yes.
fundamental misreading of what this whole thing is meant to do.
Sorry, sir,
So, I mean, isn't it a fatal flaw to go into the question of why there's a default?
we must not go up. That is what Parliament says. Even if you look at the notes to clauses for every section, statement of objective reasons, at 100 places, Bankruptcy Law Reforms Committee, they have been writing that you, NCLT, judiciary has no capacity to get into this business. That's why we are moving away from net worth concept to default. Please go by this objective figure. They have been broadly going by that, but sometimes they have strayed and Supreme Court has created confusion of late.
But
This is one.
to some extent, this expression of willful default, which I think can be traced back to RBI, this willful default, either you are a defaulter or you're not a defaulter. How do I know whether you are a willful defaulter, which then goes to the Supreme Court issue, that let us find out what were the reasons for the default and was it willful or involuntary? Once you borrowed money at a certain rate of interest for a certain period of time, I don't think this question of willful should come in at all. So I think this strikes at the root and weakens IBBI.
Yes, it weakens IBC. This is one reason that why NCLT, the process
Well,
it takes 2 years.
Why is it that we are not able to clarify that in law? I mean, ultimately, the Supreme Court is not going to rewrite the law, no? So, I mean, I totally agree with what he said. And I have one question. First of all, does this concept exist in any other country?
Many countries have the concept of a net worth. Actually, both the models are there. Net worth and default both are there. But even with net worth also, in US is net worth concept. Even with net worth also, their admission does not take much time because US follows a debtor in possession model. Company does not move away from the hands of the debtor and debtors gives a plan. But here we say that it will, as soon as it is admitted, you move out, a third person professional takes over the company, and because of 29A, most likely you will not get back your company. And that creates tussle. That's why everybody fights. The best of the advocates go to, many people went by chartered flights to Ahmedabad NCLT. So they do not want this to be admitted because they know the consequences of admission. So it is a much more hostile process in India as compared to US.
Well, hostile, but subject to interminable delay.
Should not be. Should not be. But then there are other issues also. At one time I should discuss with Dr. Bhagwati is that for the current workload, in US, their GAO works out by work study unit how much of bankruptcy judges they need. And there, by the way, term is 14 years. Somebody learns for a long time. Here, somebody comes after 60, typically after 60, 62, even 65, if they're coming from Supreme Court. They usually get 3-4 years to learn and deliver. But even with that, if I go the standard US age, they say that for an individual insolvency, the court time is 12 minutes, outside court time is 15 minutes, if I apply those numbers, assuming that we have that level of efficiency, still what our additional is that we work on division benches. Two people have to be there. In US, it's one person works because commercial things are with the market. NCLT is not supposed to apply mind. But if I apply their standards and just use the division bench, our requirement is 360 judges. Against that, we are working with the 62, and 62 was the capacity created for Company Act, and we have just put the IBC on them. So this is actually the more bigger reason why the disposal is much
So we are
less.
understaffed at the.
Absolutely understaffed.
So 1/6, so we have 16% of what we require.
Yes, and coupled with that, their own capacity to understand
Is
business.
this deliberate? You feel, now I'm asking you a political economy question. Is this deliberate? Because I'm sure there are lots of people who want to be judges on NCLTs and so on, people with the required legal qualification, somebody who's been practicing law for 25 years, from age 25 to age 50. 50 is very young.
Not that they do not get applications,
Oh, they do get it. So,
but our selection process is such that it ends up getting most of them from the government sources. Maybe
retired people usually, is that how?
yeah, retired both bureaucrats as well as judges, because as I told you, every bench has a technical member, judicial member. Judicial member has to be from judiciary, could be district judiciary, high court or Supreme Court. But the rest of the members, 80% of them come from bureaucracy, 20% of them come from market.
we have identified one fatal flaw.
Okay. So this is one, and the recovery rates. IBC, that's why as I emphasized in the beginning, IBC never intended any recovery. It is supposed to be the resolution plan. The entire IBC does not use the word recovery anywhere. But still, if somebody looks at, because we get a lot of criticism in terms of a haircut, looking at the realization through comparing this IBC route with other dedicated recovery mechanisms, like the DRT and surface I. In fact, people go to say surface I only when they feel that there is a secured asset, they can get something. People come here when they do not have enough secured assets. That's why I told the companies which are getting liquidated, when they enter the process, the assets available with them is about 5% of the claims. That means though they claim that we give a loan on full security, but when it comes to this process, we find that they come to IBC when they are left with only 5% of the assets. Whether they did not have security from the beginning or security has disappeared in between, we do not know. But despite that, the IBC when they come, the secured assets are much less, but realizations has been like this. Among the recovery modes also, this is the highest.
What is the international numbers like in this last percentage?
International numbers are there. I will come to that. Okay, this is the international number. This is the ease of doing business report of the World Bank, which was discontinued in 2020, probably may be revived. So this has been India's improvement, say 136 to 52. Recovery rate improved from 26 to 71. 72 cents per dollar. Recovery time improved from 4.3 to 1.6. But this is the outcome by the 2020. Thereafter, we have gone down drastically.
So are we saying we have plummeted from 72% in 2020 as per this chart to 16% in 23-24?
No, there is something wrong in that data actually. That means the way we calculate, the way World Bank calculates are different. The difference is, we calculate that, let's say, take any company. In some companies, we get 100% realization, and in some companies, we get 0%. It all depends on how much of assets available on the ground. But the percentage of haircut is a numerator upon denominator. I will give one example, the Videocon. Videocon resolution plan was approved. NCLT told that 95% haircut, and that made headlines. But the way that has been calculated, there is a loan of 25,000 crore SBI has given to Videocon. Somebody else has given a guarantee against that 25,000 crore. So the denominator becomes 25,000 crore guarantee, 25,000 crore loan. So denominator becomes 50,000. So this is how we calculate our denominator. We have NPA amount. NPA amount, as if actually banks maintain two sets of records. Individual ledger, the interest keep on accumulating. And as and when the time comes, they ask for the entire amount, penal interest, all things. But earlier I told that the realization was X, but it does not include certain realizations which are on the way. Sometimes the creditors get also equity. That value do not include. Value has been transferred from the company through avoidance transactions. Applications have been filed for about 4 lakh crores valued underlying avoidance transactions. But not except few 5-10 cases, those have not yet been disposed of. So that money will come to creditors. The other one is the personal guarantors, which there was a legal fight for long, but now it has been sorted out. The amount stuck up with the personal guarantors is about 3 lakh crore. So if you add up, if you rectify this numerator and denominator, you are likely to get World Bank figure of 70%. Yeah.
Number one, are you suggesting that in India still there is a kind of regulatory arbitrage going on because you alluded to some kind of other schemes like Surface I and other stuff available beyond IBC? So are companies engaging in kind of arbitrage wherein, like your point about 5% of assets, whatever liquidation value, so they go to IBC in that scenario, vis-a-vis other kind of mechanisms?
It's not really companies are choosing. Because of a 29A, in the initial days, some companies chose on their own. But once 29A came, no company would like the company to move away from his hands. They are not coming.
But don't you think that's a lacuna in the law? How does that help creditors? How does that build a credit culture in this country?
No, there are plus and minus of both the models. But today what we have, most of the cases come up on the application of a creditor, financial creditor or operational creditor. And the other guy, the debtor, has no choice. Once it is admitted, it keeps on fighting against admission. But so once admitted, they are out of they move out of the board of directors, and insolvency professional takes over the company.
Can I just ask a clarificatory question? I know I'm misusing the privileges of a chairman, but you know, this personal guarantee, what's been the record of that? Have we actually been able to enforce any personal guarantees or no?
Several, as I told, several applications have been filed claiming a guarantee amount of about 3 lakh crore. Nothing has yet been disposed of.
But I just want to understand conceptually, if I'm a debtor, I mean, yeah, I'm a borrower, I'm a lender.
Let's say you are the guarantor. You are the guarantor.
I'm a lender,
Okay.
I'm a bank, I want to lend to a company.
Yes, sir.
So it's lent against some security, which may or may not be worthwhile. But I said, no, I think I also want a personal guarantee. Okay. So I get a personal guarantee. Now the question is that as far as the company is concerned, they have nothing to do with the personal guarantee. The personal guarantee is simply a reassurance that the lender has vis-a-vis whoever does the guaranteeing. So is the implementation or recovery of that personal guarantee supposed to be part of this process or separate?
Yes, sir. It is a part of this process. But the choice is with the creditors, whether they want both the processes to start simultaneously. So in the initial days, why it happened like this is that we started with a corporate insolvency resolution. So that means only companies which have defaulted, they came here, and a company which has given a guarantee also it came. But the personal guarantor is an individual insolvency, so it was not brought into force till 2019. So in 2019, when it was brought in, there are a lot of court cases. It got sorted out maybe 2021, or there were another bout of cases got sorted out in 23.
No, but how does this process bring in an individual guarantee? I mean,
Just want to add to that. There was a number you had shared, 2,40,000 crores under personal guarantees were recovered.
Not recovered. Applications have been filed for recovery. The law is settled, sir. Both the processes can start together. The insolvency resolution process, the company and its personal guarantor can start together if the creditors wish. If they do not wish, they have the option even to start against the personal guarantor first. then against the corporate, then against the company. But generally they don't do it. They first try to get from company. But law is settled that
No, but the
whatever-
problem really is that if the court is looking at it, what is the court supposed to do with a personal guarantee? How can they enforce the guarantee? It's for you to go and sue the guy somewhere and take possession of his house, his yacht, his aircraft, or whatever.
no, sir, this law provides the insolvency resolution of personal guarantor. And
Okay.
and that process can lead to bankruptcy, lead to sale of his house, all those things are there. So if you can't recover your entire amount, we are recovering 30% through corporate insolvency, you are entitled to recover balance 70% from that personal guarantor through a resolution process.
But that is going to be done by the IBC and so on.
Yes, sir.
Not by separate courts.
No, no,
Does
no,
that make
no.
sense?
No, it is only same NCLT.
Yeah.
Same NCLT.
Does that make sense in your view?
Yes. It makes sense.
I've done some work in this space.
Hmm.
It actually makes a lot of sense.
Mhm.
Because there's a lot of misuse of that power by the commercial banks, and it also ties in with the concept of willful default. Because under willful default, you can impose a criminal case against the entrepreneur. So these are essentially the bank.
Okay, we will
mechanisms.
discuss this separately then. Okay,
all right.
don't want to interrupt.
The idea is that if both the proceedings move together, the creditors have a complete view of the individual's
Yeah, I can
financial
see that,
things.
yeah.
So that's why it has been provided that way. Yeah.
Or has been discussed. Why is that in the formula you take in the denominator both the personal guarantor as well as the credit separately? Because basically the personal guarantor is basically credit, I mean, he's acting as a backup for that, or, why is it that you're adding two separate in the denominator? You should be one single number.
I am not adding. It is when the claim is submitted, the resolution professional invites the claims, all those who have to get money from this company, please submit. So bank which has given the loan submits a claim. Guarantor also says that I am submitting a claim because in the process this company may die. I have to get money from somewhere. If I am required at all to pay to SBI, I must recover from somebody.
No, that's understood, but if it's just 25,000 as my, this thing, debt. Now technically the personal guarantor plus the company will be 25,000, but I believe you said like it will be 25,000 plus 25,000, 25,000 of the personal guarantee and 25,000 of the company. I mean that, it just doesn't.
No, it is
Make it
not
logical.
personal, it is not personal guarantee. What I'm saying is that I am the corporate debtor. I have taken a loan from SBI, 25,000 crore. So I owe 25,000 crore to SBI.
Sure.
Mr. X, let's not Mr. Another company has given guarantee to SBI on my behalf.
Sure.
So when my resolution process is going on, that company is also submitting a claim on me.
Fair enough, yes.
So bank submitted 25,000. This guy who had given guarantee, he also submitted 25,000. So my total claim become 50,000. But creditors, while giving the money, they will not give anything to him. But for calculation purposes, the total claim against the company is 50,000.
Right, double this thing anyway.
Yeah, it is double. That is the precise problem I'm saying. And that is why World Bank says that no, it's actually 72 paisa you are getting.
Thank you.
Okay. Finished?
Yeah, almost finished. So essentially, creditors are getting 72% of their claims. World Bank says 72%, but some cases we have seen in Binani, many cases, hundreds of cases, they get 100%. And there are cases like Ghotiranga or Kid, they get just 0%. So it all depends on with how much of resources you start the process.
But these numbers are only up to 2020?
These are up to December 24. March quarter data is not yet available. So companies which are getting liquidated, they are left with 5% of the claims. Companies which are getting resolved, they are left with assets valued at 19% of the claims. So a bit about this efficiency and efficacy, we discussed about the cost part. As its primary objective is resolution of stress resolution is happening. Companies are getting resolved by either resolution plan or liquidation. Time-bound resolution is not happening. Cost of resolution comparable with international. maximization of value would have been much better if the process were continued, concluded in 180, 200, 300, 400, and not like this 8 years or 10 years. And that's why we are having a discount to the fair value. We are getting about 88% of the fair value. There's a recent study from IIMA looking at the post-resolution, how those companies are performing, which have completed 3 years after resolution. They have generally found turnover has almost doubled, profitability has converged with the benchmark, market valuation, those which are listed, their market cap has tripled. And for the broader economy, we saw the TBS, the twin balance sheet problem not there. NPA has come down so drastically, credit culture has changed, and even the corporate governance has improved in the sense related party transactions or the transfer of value through avoidance transactions. These have almost disappeared now. So I'll conclude here. Thank you.
Thank you very much. Good. So let me now ask Rakesh to give his comments, observations, whatever you like.
Yeah, so let me just start by saying that to some extent, the passage of the IBC Act was almost a miracle in the sense that some of us had been working towards that kind of an act since the mid-1990s, actually. And my impression is, and Mr. Sahoo can perhaps correct me if I'm wrong, is that basically it's the Indian business owners who prevailed over all this period to not have that done. Even back in 2007 to 9, when we did a financial stability assessment program from the RBI, I think we found that the worst performance of India was in the bankruptcy procedure in terms of international comparisons. It used to take, I think, more than 20 years, even for a voluntary liquidation, voluntary bankruptcy in Indian courts. And the whole procedure was really, really, I mean, Kafkaesque, actually. And you had almost no professionalism in the whole procedure. This is, and as Mr. Sahoo had said, I'm not sure what prevailed before 1985, but 1985, the Sikh Industry Act was enacted, and the BIFR was put in place. And I don't know if there was any other country which has a concept of a Sikh company. You know, you sort of Sikh company, you know, you're sort of you're in the hospital and basically remain there forever. And the hospital was the BIFR. So it's been a really very sorry state of affairs.
More a hospice.
Hospice, yeah. That's right, good. Thank you, I'll use that in some, more like a hospice. And so none of these things were ever resolved, basically in favor of the equity owners, in the sense they continued to own the company, their assets. And something which I was very familiar with was after the 91 reforms from the Ministry of Industry, we worked very hard on that. The concept was we're doing all these reforms, introducing competition, eliminating licensing of industry, competition through FDI, competition through imports, etc. So they're bound to be bankruptcies in terms of companies having a problem. And within that, there was the textile sector was among the most sort of sickest sectors, and the engineering sector mostly based in Calcutta and Kanpur, if I'm not mistaken, and textiles also, of course, in Kanpur. And I'm just mentioning this to give you an understanding of the whole cost of this process and what Mr. Sahoo said was the objective of the whole IBC process. Was that, so for example, in Ahmedabad, I don't remember exactly, it was either 28 or 38 textile companies have been closed for years and years, okay? But there had been no resolution. And this was compounded by the fact, by the labor laws, that the workers could not be fired. Okay. So the worst sufferers were the labor. That is, you could not be fired, so you couldn't get anything, actually. But in any case, since the company was bankrupt, was not functioning at all, the mills were closed, you got no wages either. So you were neither fired, nor were you getting any wages, nor did you have any claims whatsoever. Okay. So, meanwhile, the owners had the land, had the assets. The asset of the actual factory may be zero in terms of value, but still you had the land. I'm just mentioning this to give some understanding of what the process prior to IBC entailed in terms of costs, workers, the economy as a whole. Okay, the bankers had to be very risk averse because they had no recourse. Essentially, there was no effective recourse to getting any. Excuse me. Which is why they took all these collaterals, even if they didn't work, like personal guarantees and all kinds of other collaterals and so on, even though they didn't really work. But it did mean that credit group banks were always risk averse in trying to give credit. So finally, it is really, I think this is a project in itself, in looking at, despite big reform process from 91 onwards, for 30 years, this couldn't be done, right? And this finally came with this government. So I would certainly give a lot of credit to this government for succeeding in bringing up this act. Okay, so that I think is very creditable. 10 years, what you got on the table at the bottom, 10 years is still very long. What would be the international sort of average time if you took all this stuff? 3 years, 2 years, 5 years?
No, sir, internationally, these timelines will vary because it's wide range of.
Yeah, of
countries.
course. Yeah.
The best countries
Yes.
would be about 1 year.
1 year. Okay. So let us see if the average 3 years. Okay. Still, the point is 10 to 12 years is just far too long, actually, still. And so we still need to work a lot on this process. So the rest of my comments actually are more information from some work that I have been doing with Abhishek Kumar and Divya Srinivasan on the content of the NPAs that arose, that they became huge, the whole twin balance sheet problem that people have written about and so on, after in the 2010s. So on the key misconceptions, and this will come to the sort of the resolution, etc. The key misconception that it has been claimed that these NPAs arose because of the huge credit growth in the 2000s. And that is basically incorrect. Yes, there was huge credit growth in the 2000s, but corporate credit was still small until 2008 or thereabouts. The turning point came around 2008-9 or so. So most of the bad loans that were given by banks were after 2008. Of course, when I say this, people look at it, you only, because you were an RBI as a deputy governor till 2009, think it didn't happen during my time. But you just look at the data. And it is a fact, it is true that the growth rate after 2008 or so declined a lot in terms of total credit. But because of the higher growth, the base had become much higher. So in absolute terms, even a smaller growth rate gave you much higher battle. Two, that we found that of the big gross NPAs in the 2010s, about a third were from the metal sector and about a third were from infrastructure. Interestingly enough, it's not very easy. It's taken us 3 years to get these data. Interestingly, it's very difficult to get these data. And again, it's been helped now by the IBBI. So just to give an infrastructure, for example, infrastructure in terms of the share of non-food credit was about 3.7% in 2007, and it went up after that to about 15% by 2015, which gives an idea that, look, there was a large corporate credit taking place, two large projects, one side the metal sector, the other side the infrastructure sector. And about 60% of these projects in the infrastructure sector were concentrated by 24 industrial groups, business groups. And this goes back to the original problem in the sense that I'm sort of jumping in the sense that I'm assuming that because prior to the IBC, that industrial groups assumed that nothing will happen to them. So that's why they would invest in all these things. And we'll take a big loan and so on. In the infrastructure, 70% was power and roads, the power sector and roads. All private sector, okay, which was very interesting. Public sector banks lending to all these private sector companies. Another thing we found very interesting in terms of public sector bank performance, that if you look at the companies to which they gave these large loans, ex ante, that is prior to giving the loans, these were good companies. So in the sense that their screening was good, interestingly, actually. They started deteriorating after the loan had been given or the loan process had started. So that's also very interesting. And in that, what we found is that it's sort of not that related to IBBI, but it's sort of giving some sense of you've given some numbers on the large NPAs of banks, and which had gone up to 2016, I think, or 2015 was the maximum. That this is what contributed to it. That after the North Atlantic financial crisis of 2008-9, because the whole world economy had slowed down, there was excess capacity of in China of metal and other things, other commodities, and the prices shot down, all the metal sector. And so it was an external shock in a sense that all these projects had been put in process, and then they came a cropper because the global metal prices came down, was transmitted here. To huge, and this is where you come in, huge promotion of PPP in that period. And in the infrastructure sector, I'm as much of a culprit as Montek is, in the sense that it was my infrastructure report in 1996-97, which in some sense promoted the concept of private investment in infrastructure. So by which, in the 1990s, by which time we had wound up the DFIs, the financial institutions, for industrial lending. Earlier, there wasn't much infrastructure lending in any case because everything was in the private sector. Of course, the public sector financing things like the Power Finance Corporation, the IRFC, the Railways Finance Corporation, etc. But and they, of course, essentially lend to public sector companies. So what is interesting is a lot of these problems arose in the private sector. And because there were no DFIs, development finance institutions, the job fell on public sector banks. And in some sense, public policy promoting PPP. So they were, in some sense, one can say that, look, why do you have public sector banks? Why do you need public sector banks at all, conceptually? I'm talking about the practicalities, okay? That presumably the government or the country or the public or whatever wants public sector banks to promote, to carry out public policy. You may see it as bad or good, but otherwise there's no need to have public sector banks conceptually, okay? So the public sector banks did their job, and they did a lot of lending to infrastructure, and the 50% of the claims with IBBI came from infrastructure sector, also in liquidation actually. So and if you look at the numbers, that as a consequence of all this.
When you say infrastructure, you include power.
Yeah, power and basically of the infrastructure, most about power and roads. And also what is interesting here is, why do the power sector companies who borrowed get into trouble? Most of it was generation actually. But again, because of bad public policy, which we've studied that here a lot in terms of the the distribution companies all the all the government policies which have which have created problems for the distribution companies collecting dues and so on, which then goes up the chain through the transmission companies and the generation companies. So in some sense, a lot of this problem has, at least in the infrastructure sector, same thing to do with roads in terms of land acquisition problems, delays, and all the rest. Plus, of course, economic slowdown that took place at that time. So now prior to the IBC, there would have been almost no recourse. Okay, and what the IBC has done is, even though the recovery number, I don't have a good sense of how to evaluate the recovery numbers, but what it has meant, to my understanding, is that because there is some recovery, there is a process that I would imagine, and I think this is what Mr. Sahoo was saying, that entrepreneurs or promoters are now more careful in what they want to invest in. And there's been a clean-out process through the IBC so that the NPAs have come down drastically. Also, I presume that because, and the thing is that what is interesting to see in this is that prior to IBC, when all this took place and all these NPAs happened, large gross NPAs, the whole credit culture, whole credit growth came down tremendously and slowed down the economy as a whole, including particularly industrial, new industries, new industrial corporate lending, etc. Now, I just gave all this to give a sense of, look, how things have turned out. And that in some sense today, the banking sector is again healthy. What I'm now, since the last 2 days, been worrying about now is I don't know if there are major metals or industrial projects in action now through bank lending. Because if the current sort of stuff continues, again, commodity prices are going to take a crash. Oil has already taken a crash. And so we have to, I think today, once again, I think the finance ministry, the RBI, the banks themselves need to again start looking at where their loans are today in terms of large corporate loans. Okay, because you could have the same thing could happen again. And then the question in my mind is, will it be less than before because in more responsible lending, because promoters have been reluctant? Is there also a cause of lower private investment that we've been experiencing for the last number of years, and prospectively also, in that earlier you may have got many of these bad loans and bad projects and so on, but maybe people were less risk averse, both from the investor side as well as the banking side. Now it's possible that because of this, and I'm not saying this is a bad thing at all, don't misunderstand me, but is it the case that because of IBC coming in, the promoters have become more risk averse because of the obvious consequences that Mr. Sahoo outlined, and with also, of course, the lenders have become more risk averse? I'll stop there.
Good. Thank you very much. Okay, let's open it up for discussion. I think let's focus the discussion on the IBC portion. I mean, the larger issues are actually in many ways more interesting, but let's focus on IBC, how it's doing, does it compare internationally, blah, blah, blah. So, questions? Yes, sir.
IBC is 2016, IBBI has been in existence for roughly the same time. In 2021, I think somewhere as COVID was waning, still around, NABFID was set up, National Bank for Financing Infrastructure and Development. As we all know, around about independence, IFCI was set up, and then ICICI, IBBI. These are all institutions which are supposed to promote lending for infrastructure in a country which had inadequate infrastructure. Then all these banks or term lending institutions, as they were called, reverse merged themselves and became banks. And the latest, of course, is IDFC Bank, which is merged with First Capital to become IDFC First Bank. This does not tell me that there is great confidence in the IBC process, but I'll defer to what Sahoo has to say. Because I also look at lending, term lending. That means for average maturities beyond 5 years. I look at public sector banks, private banks, and foreign banks. Foreign banks don't take any exposure at all in terms of term lending beyond 5 years. Foreign banks have a lot of capital, not necessarily deposits from within India, which they could if they open themselves up. They prefer to hang around the large metro areas and not diversify and set up branches in smaller places. The very fact that foreign banks are not out there doing term lending, the fact that private banks are a fraction of what public sector banks are doing, is that a reflection of confidence in IBFC? And plus this whole thing of government having to set up yet another term lending institution, it's only a matter of time, I suppose. NABFID will apply for banking license to RBI and reverse merge itself into a bank. So is that at all true, or am I reading too much into the fact that these term lending institutions have all become banks, and NABFID as recently as 21, which means 6 years after, or 5 years after the IBC, government has set up yet another term lending institution?
But haven't the term lending institutions become banks because that's the only way they can mobilize deposits? Otherwise, they'd have to go to the bond market, which we've killed by having ridiculously high
It's not
SLR.
Because they get some tax benefit. As term lending institutions, they have to pay less tax on the on certain kinds of deposits. So whether it is for overall reasons in the banking sector that term lending institutions can't work, or is it because of concern about recovery on long maturity loans?
No, but the real question, isn't it, that if we were to cut the SLR to 10%, and I mean, it doesn't stop the government from borrowing, but then the government would have to borrow in the bond market. And I mean, interest rates would be affected and the whole thing would become more, the market would draw savings. And these guys, the term lending institutions, would raise bonds. Instead, I mean, we've created a banking system in which the preemption of credit is excessive in order to fund the deficit. You can't expect these guys to raise any money unless you give it to them. And in the old days, that's what they did. And the government gave money to IBBI in order to on-lend. I think there's a more fundamental problem here, which is directly connected with the suppression of a market for long-term loans in favor of both the central government and the state governments.
Yeah, so I think the question is the central problem, the high fiscal deficits of both central and state governments, right? Or which way is the causation? That is it the case that because of SLR and also the other regulations to insurance companies, etc., to invest in government securities, which therefore induces the government to do more borrowing? Or is it that you, for financial stability reasons, you have to have SLR if the government has this fiscal deficit? I don't have an answer to that, but I think
we're not allowing the market for loans to function if the central government and the state government are going to sort of have a preferential access.
No, I know, but the question, they only have because they have large borrowing needs. And also, the point is that they have to think of who are the lenders in the system. Okay, in countries where the bond markets work, it's not retail lenders who lend to in bond markets.
Sure.
Okay, or who buy bonds. It is all the institutional lenders who invest in.
No, but that's the point is we are pushing all these mutual funds to buy stocks because we're not actually giving the debt market a decent run for its money.
But it's actually mostly pension funds, insurance funds, etc., who lend more in the bond market. And those financial institutions are still not big enough here, and not enough of them also. Hopefully, they will start becoming more, right? Because earlier, of course, only Life Insurance Corporation. And then government told them this is the bonds you buy.
What is the current SLR? About 18?
What, 18 or 19, something like
So
that.
what would happen if you were to cut it at least to 12?
Government borrowing costs will go up, no doubt.
Shouldn't they?
Well, no, they should, but again, this question of what will happen to your fisc.
Well, it'll
So
force you
question-
to realize that it's worse than you think.
Well, the question, that is, I mean, that is what people like us say, but is the government sensitive to that? I don't know. Its behavior for the last 75 years says that it is not sensitive to the cost of
On
its
the
borrowing.
contrary, the government is taking a lot of pride in fiscal rectitude. You can't say that they're not sensitive, no?
I have a
Yeah.
question, but not related to this kind of thing.
Good,
Okay,
good,
okay.
good. Yeah, we were going off the point.
Yeah, because this is a much wider.
Yes.
Yes,
correct,
that's
correct,
true. I
correct,
agree.
Correct.
The whole presentation, I did not see a differentiation.
Can you
between
speak into the mic,
between
Lavi?
the SMEs, the larger ones. For instance, these numbers like 12 years, do they apply to the SME one as well, or is this typically larger?
Okay, I'll clarify that. There's some clarification about 10 to 12 years in general. But sir, the very first thing formally was Dr. Omkar Goswami committee report.
Exactly.
Yeah,
exactly.
so very
Exactly.
first idea along with the
Yes.
liberalization in 91, 92,
Yes.
it was thought of.
Yes. That was after he worked with me
but
on
as you told,
LTAs. Yeah. On 6
Vested
companies.
interest didn't
Yeah.
allow this to happen actually. Even after IBC was enacted, it was enacted in May 2016. That year's economic survey, that means the February 17 economic survey, made a very detailed argument devoting 5-6 pages saying that IBC will not work.
Oh,
Government of India's economic survey saying that IBC will not work, we need a bad bank.
ah,
And that demand continued till they got a bad bank in 21 or 22. And rightly, sir, as you told that government, the big thing they did is that 29A, people, that's why people had opposed then and continue to oppose now also IBC because of this fear that the company will move away from their hands. About the 10 to 12 year
But
things.
by the way,
actually-
was it felt that I mean, I can see the logic for a bad bank, but was it felt that the bad bank would be a substitute for IBC? In other words, you dump your
at
dud
that
loans
time-
on the bank with no power for the bank to do anything to recover.
No, at that time, their argument was that IBC is in an nascent stage, it can't take the load. So we need to have an alternative for next 3, 4, 5 years before IBC comes into really force. But that group finally got it. They kept on every year trying and finally got it. And IBBI kept on opposing this idea. And so that 10 to 12 year, I will clarify that. As I will clarify that, this
1, 2,
This
3.
First, I told 3 to 5 years for initiation is nothing to do with IBC. That means a creditor is trying other options. Maybe he thinks that this is not the right time to initiate the process. Supposing there is extreme example of COVID time. If I do it, the company will be liquidated. So they take commercial call, maybe sometimes non-commercial call. So these 3 to 5 years is completely outside IBC. So I'm saying that 12 years I'm calculating just to say that the value erodes over 12 years. That's why the realization becomes less. So past 3 to 5 years is outside IBC. 2 years admission, that is not really the process. We take time to decide whether to admit or not. The figure which can be internationally compared is the third one, that 2 years which the corporate insolvency resolution process takes. Beyond that, the comparison of what we see in ease of doing business figures, that relates only to this CRP 2 years, not the liquidation even in 3 years, that is also outside that. So international comparison is to seen only in relation to CRP that 2 years.
No, I'm just
Yeah.
clarifying. Because if an SME is involved, and it's a specific
I'll come to
SMEs,
that.
right? Unless it is completely liquidated, the entrepreneur is not free to start again.
Yeah. So I'll come to that. But the figures which you compare internationally is only about that. This is 2 years CRP. Thereafter, liquidation process starts. As I told you, in US, they start liquidation process directly. So 75% they decided this is a gone case, we will start liquidation. And in 25% cases, they go for resolution. Of them, some end up in the liquidation. Here we say that we don't want to take chance, our market could go wrong, let a collective body take the call. But the SME part is slightly different. Internationally, we have something called pre-pack. We have a pre-pack, it is not working. There are reasons why it is not working. But most of the SMEs go through that pre-pack route. Pre-pack route sometimes happens, it gets concluded in matters of hours, not even days. So that route is different. That means you agree upon the creditors and debtors, this is what we want to do, and just go and submit before a court and matter is over. Parties are already decided. We also wanted something like that, but the way we structured it is not working. So most MSMEs, they go through a different route. But today, everything is coming here. And here, initially, few MSMEs came because the threshold was default of 1 lakh. During COVID time, it was increased to 1 crore. So because of that, at least the MSHG, micro and small, they are out of this. And MS pre-pack was done for MSME, it's not working.
Move on to the other question because we're going to lack of time. I think we need preference to the lady. We haven't had any woman asking questions so far. Then I come back to the others.
Thank you. Thanks for the presentation. So I just have like little curious to know about, like, as like Lavish also mentioned about the reverse bankrupts, like the ones, the companies which are bankrupt and then they are like coming back to businesses. What are the timeline and the complexity in there, and also in like how, at which stage of like whatever you have shown is like the merger and acquisition is placed? Is it also under the purview of IBC and NCLT, or companies before filing the bankruptcy they itself do it, or do as a kind of like a role of facilitator? Is somewhere ICT also plays a role? So little bit about M&A. Yeah, thank you.
So as I clarified, companies generally, they are not filing for insolvency. And they are not filing only because of the fear that company will go out of their hands. Wherever they want merger and amalgamation, those restructuring things, they go through the section 230 route. It goes through same NCLT, but the route is different. And generally, those are some rewriting the rights of the shareholders, and in very few cases actually about the rewriting the debtors' rights or debtors' interests.
Okay.
But this law says that once this company's CRP is over, it has proceeded to liquidation, then it is possible also to propose a merger and amalgamation. So that means there are two routes of merger and amalgamation, one normal 230 and one that 230 will come in invoked while you are here in the liquidation process. But the numbers of going through this is very, very big.
Okay. I think you had a question.
Thank you. My question was also going to be about the pre-pack insolvency resolution process. I think in the last 4 years, there have been a total of 7 or 8 resolution plans that have been approved under it. So could you shed some more light on why that's failed and how we can take that forward?
Pre-pack typically is a market evolution. In the United Kingdom, they do it under.
What is pre-pack?
Pre-pack is the parties do the cooking beforehand and so come to a picnic spot and serve it.
Okay.
So they have prepared, they have done at backside, informally, they agreed, debtor and creditor agreed, this is the resolution we'll do. And after they are ready, they go to court and say that this is what we have done, please bless it.
Okay. I think you had a question?
No, I couldn't answer fully.
Yeah, I'll come to you next then.
Okay.
No?
No,
Yes, no, that gentleman's question.
I have not answered, sir.
Oh, he has to
I'll come to you also.
he has to answer this. No, he has to still answer the question raised.
In the blank.
Yeah, he has to answer that question, repeat
No,
that
So
question.
actually, I answered to
Yes,
Sar's
yes,
question,
yes.
not to
Yes.
his question. So pre-pack happens, as I told in the UK, something called they have a IPG practice, insolvency process practice number system, completely market driven. But here people wanted that, please provide it in the statute. And there is a committee to give a framework. That committee told that please put one line in the statute, everything will be in the regulations. And they gave some standards that the creditors' approval can be with 50%, shareholder approval can be with 50%, and certain other things were given. But government decided to put everything in the statute, increase that 50 to 66, another 50 shareholders to 75, which are impossible to get before. People will vote for it only when they see a product. But if you put much before they see the product, things do not work. And problem is that the chapter on pre-pack in the statute is much longer than the standard one. So you can't change that easily also. So that's why practically it's not working.
Thank you. Next, yes, please. I
No.
may have lost the order, for which I apologize.
No problem.
But you and then Shishir, I think. Okay.
Thank you so much. Actually, my question is a little specific because you mentioned that about 1100 plus, there have been resolutions for about 1100 plus companies. What is the scenario with respect to the real estate companies, very particularly because in quite a few of them, it's mainly also the investments by the home buyers who are really suffering quite a lot. And if there have been solutions, what has been the time frame? That's very.
No, I think there was some political part to this decision. At least when this JP Infra went to insolvency process, there are 30,000 home buyers. Home buyers wanted that we want to have a say in the resolution process. And we did not have a comparable thing internationally. So either we have a normal real estate company where the financing is through debt and equity, or you have a financial service provider which relies on the public deposits. So internationally, there is nothing called in between these two. But the real estate builders, they come in between these two. They do not fund from debt and equity. They do not fund from deposits. They fund their business from the prospective home buyers, who are actually customers. And the priority rule I talked about, priority rule has a relationship that those who will be at the higher in the list, who have least risk. The equity guy has taken maximum risk, so he will be at the bottom of the list. And that is the broadly principle across insolvencies. But this kind of a real estate, since it does not exist internationally, that model was not provided in IBC. With the JP Infra, people wanted that we want to decide our fate, let us have the rights. Government readily agreed. They were made financial.
Salary is
So that really does not work. They should have been the customers, and customers should have a higher right in the priority above the creditors. If you have that, problem will be sorted out actually.
Have there been any resolution?
Yes, there have been quite a few resolutions, including JP Infra. There have been quite a few, but it's not very suitable for that.
I'm confused. Customers, creditors, yeah, they're the same people, no?
That's what I'm saying.
The home buyers are the creditors and the customers.
So if you once identify that you are a creditor, then you get rights of creditors along with other creditors. You sit in the committee of creditors, vote for that, you decide your fate and decide how much you will get, how much others will get. But if they
I
are
want
treated as
don't want to
customers,
sort of rush you, but let's can we just, you first and then Shishir and then somebody here, you wanted to, quickly.
No, it's there.
Thank you. Thank you for the presentation.
Can
I
you
had,
stand up? It's easier for us to, yeah.
thank you for the presentation. I have two short questions. One is on the public sector companies and how that they have a lot of non-performing assets, but do they come into the IBC, and how open are public sector companies actually being subject to IBC procedures? Second is, I think during my time in law school, the NCLT was merging the powers with regard to taking more of the competition appellate board's powers. And has that really increased the burden on the NCLAT in terms of doing also the competition law work, or has that been a good resolution, you think?
so IBC covers companies, it covers all PSU companies. Quite a few have gone through, maybe at least 40, 50 PSUs have gone through this process by now. It's a routine now.
That's interesting.
Yeah, NCLT,
Anyone been wound up yet?
yes,
Which one?
some Garden Reach, somebody in Calcutta, say railway enterprise.
Garden Reach.
Okay.
Hindustan,
Garden Reach, okay.
Hindustan Papers. So many actually.
Okay, okay,
Initially, the bureaucracy was a little hesitant, but finally they accepted it.
very good. Actually.
So NCLT is only Companies Act and IBC. Competition matters do not come here. Competition matters come to NCLT. Actually, our problem is at NCLT level, capacity constraint is at NCLT level, not so much at NCLT level. In any case, the number of orders passed by Competition Commission in a year is at best in sometimes in 1 digit, maybe sometimes you can go to 10, 20. So these numbers are not very alarming.
Okay, Trisha?
Yeah, just very quickly, then I'm curious to know how are the companies run over these 10, 12 years? Who's responsible for managing the companies during this period? I may have missed this since I joined a little late.
No, again, coming back, I'm move away from 10 to 12 years. Is it the past 3 to 5 years, companies having normal life. There's a default. People have not taken a decision whether to start process or not. Next 2 years admission, also normal life goes on. Only when the IBC process starts after there's been 2 brackets here, it starts from there. From that date, the day it is admitted, an insolvency resolution professional replaces the board of directors. It is in charge of running the business as a going concern and also supervising the process which ends up in the resolution plan or liquidation.
How is that professional chosen?
And that resolution professional works under the guidance on many things is bound, but under the guidance of the committee of creditors, the decision-making authority about the resolution is the committee of creditors. The resolution professionals, they have a system of qualification examination, they are empaneled to the IBBI, but it is the market they choose. The guy who goes and files the application to the NCLT gives you the name of an interim resolution professional. He will run only for 1 month. Within 1 month, committee of creditors will come up. There will be a collective body to decide who will replace him. And they have also power to replace as and when they.
How do you fix his remuneration? Is it lowest tender? The cheapest guy gets it, or what do you do?
No, it's not fixed actually. I think now, yeah, there's some fixes that has happened very recently. It was completely market driven till recently.
No, what do you mean market driven?
Market driven, it's all parties negotiate among themselves.
Oh,
There's
the
no,
creditors decide who to give it to.
yeah.
Okay.
Why does
yes.
it take, sorry, why does it take 2 years for admission?
I told you one is the capacity constraint, just they don't have the numbers.
In the
NCLT.
NCLT.
The other is the debtor fights it tooth and nail, finds hundreds of applications, so goes up to Supreme Court, and so it is not admitted.
I have a question for Dr. Mohan. Given the fundamental problem inflicting banking, which is asset liability mismatch, the logical transformation needs to be from us shifting from a banking driven credit growth model to a private bond market, corporate bond market driven growth model. This is the case in US. So why is the RBI and Government of India, both the Main Street and Ministry of Finance, not willing to let go and allowing a private thriving corporate bond market in India to take roots? What prevents us?
First, it is false to say that they're not allowing the bond market to function. There's nothing that is either the government is doing or the RBI is doing, it just says bond market shouldn't function. In fact, they've been trying like mad to make the bond market function. That's number one. Okay. I think what is more important is that if you look at the developed bond markets, in almost all of them, certainly the United States, they're dominated by government borrowing of different kinds. In the US, it's the federal government, state governments, also city governments, municipal bonds. Okay, so these are all in some sense, in some sense, guaranteed. Okay, the second big portion of the US bond market is to do with the Fannie Mae, Freddie Mac, etc., which are although not formally guaranteed by the government. But when push came to shove in 2008-9, the market's view of them being guaranteed came to be true. Okay, so it's only a small part. I don't remember the numbers. I did look at it some time back. I think it's only about 1/3 or so, but I don't remember exactly that the bond market, the private bond, corporate bond market share. But those numbers keep changing. Second, that for a bond market to function, right? The reason why the government securities market, bond market functions relatively well, but still a lot of problems there, is because a lot of reissuance. Okay, for a bond to be liquid, it needs reissuance. So, for example, what does the government do? It may issue, let's say, a 10-year bond today, expiring in 10 years from now. That is 2035. Okay. What it does is that it will issue a 7-year bond. It will be the same bond 2 years later, which will be an 8-year bond. Okay, but it's the same bond. So you keep the supply up. Okay, so there has to be enough supply in the market for the bond market to be liquid. Now in India, there are not that many companies who can do that. There are continual bond issuance. Two, those who can find it cheaper to go abroad to borrow. Because the largest companies in India borrow abroad through ECB, etc. Okay. And third, as I was saying earlier to Montek, that we still don't have enough institutional lenders in the bond market to buy the bonds, because our pension funds are still in the infancy, very small. Similarly, insurance companies are still very small because of our legacy of all these things being in the public sector, right? The provident funds are basic. I mean, there's essentially governed by the government, etc. So there's a real issue of the number of players who have the demand for bonds. Similarly, the problem in the number of companies can actually float bonds. In the case of infrastructure, because by definition an SPV has no record. You found an SPV, so there's no recourse to the promoter. That's why I have an SPV. So it's very difficult for the bond market for them to get credit ratings. They do, but it's not easy for them to get credit ratings. It's very difficult for the market to have faith in them because there's no recourse. So I think the problem with the bond market is much more complex than the general idea that it has been suppressed.
No, but I think comes back to what we said earlier.
Yeah, exactly.
While I agree with you, it's much more complex. I mean, since we are becoming Viksit Bharat in 2047, we ought to have a strategy for how's the bond market going to develop. Are we going to remain a public sector dominated high SLR banking system even when we are Viksit Bharat? Or are we going to transit to maybe the SLR is going to go down from 18% to 10%? And you do that 1% a year. Same thing for LIC. Huge amount of LIC has to go into government bonds. So I think we are not bringing about the transition we need in order for the bond market to actually.
No, as I said, there's a chicken and egg in the sense that if the government can reduce its fiscal deficit, both center and the state governments, all right, how would that happen? Either it reduces expenditure a lot, as it is, it's not spending enough on all kinds of social activity like health and education in particular. This means raising more revenue, or there's a lot of inefficiency or reducing subsidies or something. You've got to do something to reduce the fiscal deficit. And as long as that is there, I mean, in some sense, we have one of the highest among G20 countries, among developing countries, emerging markets, we have among the highest debt to GDP rate, public debt to GDP ratios. And yet the country, there hasn't been a financial sector implosion. It's all because we've been fixing things. So, I mean, all I'm saying is that reducing SLR won't solve the problem. You might get more financial instability.
1% a year
versus RBI.
1%
I'm
a year.
also the finance minister.
Now
With you.
Now he's more RBI.
No, I think
it's not a question of
in my
RBI.
view,
I'm just kidding.
No, it's not a question of RBI.
hang on. RBI should stop pretending that it's financing the deficit. It should be arguing what is necessary for the stability of the financial system. That should mean cutting down the SLR.
No,
Let
stability.
the government decide how to finance the deficit.
No.
If you become, or you meaning at the RBI, it becomes sort of you've got to finance the deficit, then forget it. I mean, don't have a financial market.
No,
That's the point.
it's the financial stability issue that's important.
No, that's for you to, the stability issue would simply mean that the fiscal discipline would be enforced on the government. And you could do that very easily. I mean, you meaning the RBI can, look, at the moment, the RBI is observing no discipline whatsoever because the interest differential between the most broke state government and the solidest state government is negligible. So they're just not doing their job.
But is the differential between in other federal states, countries also, there's not a great differential between states.
But there's not that
But-
much
but
variation.
because there is still an implicit guarantee from the central government, just like there was with ferry back, ferry way, etc. There's a clear implicit guarantee that
Not
implicit, not
Orange County.
no, not. I'm saying
Yes,
implicit.
the home loans there was through
Yes.
that because they have
So,
a federal.
There's an
thing over
implicit
there.
civil municipal bonds in. I mean, this is
No, I'm saying,
similarly
I mean,
fund,
this is meant for the audience.
fund briefs in Germany. Look,
I think we
the
need to
German bond
raise-
market, German bond market is dominated by the Bunds, that is the federal government, and the fund briefs, which are the state government equivalents and local and so on. So people understand the bond market in India, and the international institutions have been pushing this without understanding it. The problem with the bond market. I'm not saying the bond market shouldn't develop.
You are actually.
So I'm not. I'm sorry. I'm not wanting. That's completely wrong.
Okay,
May I ask
Yeah.
a question?
of course. We can go outside and conduct our discussion.
The principal speaker.
I was, Jaimini, I was provoked.
Of course, that was
Because
the
I
whole
provoked
idea.
him.
No, it's all good fun and it's all getting recorded and will be put out on YouTube.
Good, good. Excellent.
No, it's recorded and then put out. That's my understanding.
Yes.
Yeah, so I don't know whether you already answered it in all this by, I'm thinking of bond markets internationally, national. NABFID. It's not a bad
NABFID.
fact.
No,
So-
not NAFED.
So NABFID, what was the reason to set up NABFID? We are again going back to this thing. After some time, NABFID will request RBI for a banking license, saying, "Arey bhai, let us take deposits." Because NABFID right now cannot take deposits. So whether it was IFCI, whether it was ICICI, whether it was IDBI, whether it is IDFC, the one institution I know a lot about is IDFC Limited. And I was part of the process which made it into a bank and was on the board of IDFC First Bank till I exhausted that 10-year limit. So I have met these people and they are very clear in their minds that they just don't want to be a term lending institution, which tells me that they are worried about recovering whatever medium to long-term loans they make. Now, these are the bankers of our country. Are they risk averse? I don't know. Are they unaware of the advances that the IBBI has made in trying to give some sense of relief to creditors that a reasonably open, reasonably fair process will be? Or there are still some doubts, and that is why the government comes up with NABFID. What do you think?
So, Jaimini, just to add to your question, that since you already had an IFFCL, whatever it's called, Infrastructure Finance, IFCL, that already you have IFCL, why have another one?
Yes,
NABFID. That I don't understand.
unless it is to give somebody a job, which is also quite.
Jobs
No,
can
I
be
have no
given
answer
for
for
all those jobs vacant in the NCLAT.
That's true. That's true also. No, that don't want to NCL to be too efficient.
Ah, that's all.
Because,
I think.
Sorry.
No, no, I have no answer
You
to
don't-
this question.
you don't want to
I
interfere.
government does, I have no answer.
I think that.
No, I think Rajesh-
it doesn't make any
Please.
sense to you?
Yeah, doesn't make any sense.
I
But,
think
but
the lady
that is
there
different
had a
question.
question, so you're next.
Yeah, yeah. No, it's not a bad.
Please
fact.
grab a
No,
mic.
yeah.
Rajesh.
Thank you. It's a lot of learning for me. I connected with what Dr. Bhagwati was mentioning. Have not been able to understand what was the logic in mid-90s when the financial reforms were being undertaken to do away with the development DFIs. And suddenly, 10 years later, we wake up to what you mentioned, IIFCL. So what was the closing down evening sound and what brought the new wave of thinking with IIFCL being established in 2006, I think, if I'm not wrong. My second related question is to Mr. Sahoo, that when the defaulting companies or, where resolution plans and liquidations are being, do we also look at what was lent by the erstwhile DFIs versus
the public sector lending, because erstwhile DFI's lending was relatively long-term since they were not banks at that time. And the bank lending, which Dr. Mohan has clearly said that public sector banks first saw the companies are behaving well and they're good, but maybe for some reason later they became defaulters. So is there any demonstration of what happened to the DFI's loans that were taken versus the private sector banks or public sector banks for that?
No, I don't think IBC tracks that data. IBC looks at the default only and does not matter whether that default is in a debenture, loan, developmental bank loan. The source is not a material, particularly because first IBC does not care about that. But more important is that these loans get shifted from one person to another person. So most often all the DFI loans are with some asset reconstruction company. 5 times, 10 times assigned, reassigned. So not possible to know actually which originated from DFIs.
Question?
Sorry, my question is to Mr. Ahluwalia. I recently,
Okay, go ahead.
yeah, I recently saw your interview and you said that India should, reduce tariffs and depreciate the rupee. And my question to you is, while a weaker rupee may boost the exports, but it also raises the, industries which are dependent on the imports, and it can increase, the decreased value of a rupee can increase the the amount of imports, right? So how do you foresee the financially vulnerable firms and who are already working on very thin margins? And could this lead to a surge in the insolvency cases under IBC Act? Do you think that?
Well, I mean, we're moving from one set of subjects to a completely
So
different.
it's also IBC.
Hmm?
It's also IBC.
I mean,
In what sense?
Greater insolvency because of your recommendation.
yeah. You said that tariffs, decreasing the value of rupee
Yeah.
on international market. Do you think that it can increase the insolvency of the companies who are already working on very thin margins right now?
No, clearly, if a company has actually hedged its borrowings,
Yeah.
it wouldn't make any difference at all. Okay? Now, you're right. If a company has not hedged its borrowing, and he mentioned there are big shots who want to borrow abroad, that would be, by the way, a very interesting study, because all of them seem to be under the impression that our rupee is now strong, whereas virtually all the economists are now actually saying it's overvalued in real terms. So deep down, they're kind of hoping that it'll depreciate, okay? And I don't know whether our corporate financiers build that in the sense that you can borrow abroad at X% in dollar terms, but if the rupee depreciates by 3% a year, it's going to cost 7%. And what will it cost if you borrowed in rupee terms? I don't know if they're doing that. This is a side, but certainly you're right that if you change the exchange rate, whoever's currently in a particular financial system will get hit. But remember, when you're making a long-term change or even a medium-term change, don't get bothered about every little thing, because hundreds of things are happening that are altering their business. And by and large, they learn how to deal with it. So you can rightly address the question, is it a good idea to cut tariffs and offset that by an exchange rate? Incidentally, those who are working on thin margins, you're worried about the effect of the exchange rate. But think of the benefit to exporters who are also working on very thin. Bonanza. I mean, the real point is, imagine to yourself a situation where there is a uniform 10% import duty, okay? That is actually a tax on exports because it's allowing you to maintain an overvalued exchange rate. So what I'm saying is, depreciate the exchange rate, cut the duty. These guys remain where they are. Exporters have a boom, okay? And I'm just applying that logic generally. Now, you can rightly say that if the average duty is 10%, but some guys have only 5% and other guys have 15%, these fellows, the 15% fellows will not be fully compensated. That's always going to be the case. Something or the other will change. So that was my logic. But as far as the IBC kind of things is concerned, I mean, look, these are guys who are facing day-to-day market variation of all kinds. So surely they're getting shocked all over the place. I wouldn't link the two at all. I don't know if that's persuasive, but I think maybe if there's one other person who wants to ask a question, we have one. Okay,
On this last question,
two, lady first, she's
Yeah.
got the phone.
yeah, on this last question, I fully agree with him.
Go ahead.
My question is to Mr. Sahoo. So you had mentioned that the haircuts are calculated in a specific way and that the denominator tends to be overvalued and numerator undervalued, if I'm not wrong about that.
Correct.
So I wanted to ask, to what extent does this calculation problem actually impact the amount which is recovered or lost to the creditors during the process?
Can you repeat? Can you repeat?
So to what extent does this calculation problem that you had mentioned with the numerator and denominator actually impact the creditors who lose out on the money because of these haircuts, in actual sense, the value?
I wonder if they're really.
No, difficult to answer this question because I told you some future realizations are there. How much would be realized? I do not know. What's the name? But I would believe that if all these are factored in, we should reach close to World Bank figure of 72%.
Last question.
Hello. So actually, my question is that I'm doing PhD on the same topic, and my question comes from a lot of the recent academic studies in India who have evaluated the impact of IBC, and they all have a general consensus that this idea that the control of the firm is taken away from the debtors and given to the COC. It actually pushes firms to reduce their reliance on external finance, so they are borrowing less. They are reducing their investment in R&D and something like that. So I have two questions basically. First is, does that beat the whole purpose with which IBC was started, that the money which is stuck in NPAs will be brought back and put back in the market? And second question, I mean, from the government's point of view, are they actually taking this into consideration that this point might have some changes, there might be something to offset this effect, something like that?
So I think the NPA part, we have seen there is a continuous improvement on NPA part, but not necessarily whether the people are willing to borrow given the consequences. And those who are lending also, they are feeling that are they becoming a more powerful, are they more comfortable to lend? So these two forces are working. On one side, the borrowers are becoming a little reluctant unless they're confident they have a good business model. And the investors, they are also looking at whether we are putting the money in the right place. But the data, I don't have the data exactly, but there are studies already and data also, if you look at Prime database, over last 5-6 years, the corporate debt issued has increased and being attributed to IBC.
Okay, yeah, thank you. Well, thanks everybody. Thank you, Dr. Sahoo, and all of you and the audience for making it so interesting. Thanks.
And thanks to the chairman for making it even more interesting.
Yeah.